Hello viewers, welcome to my channel. I'm Hasham Ali Khan. So now I'm continuing the discussion on breach of contract. The last video I have explained you about the meaning of breach of contract and the types of breach of contract like actual breach of contract and anticipatory breach of contract. Then I have explained you about the remedies available to the injured party when there is a breach of contract. The 5 remedies are there. The first remedy is rescission of the contract. Second one is suing for specific performance. Third one, damages. And fourth one, suing for injunction. And last one, quantum merit. These are the 5 remedies. Normally these 5 remedies are available in the hands of the aggrieved party in case of breach of contract. Among these 5 remedies, the most commonly used remedy is damages. So most often, whenever there is a breach of contract, very frequently, most commonly used remedy is damages. So now in this video, I'm going to explain you about the meaning of the term damages and what are the different types of damages that can be claimed by the injured party in a breach of contract. So this video is the continuation of the last video. So if you have watched the last video, definitely you can be able to understand this one, otherwise not. So I suggest you to go to the playlist of my channel. Select the subject business law. Select the topic breach of contract. In that topic, you will find this discussion about the damages. So now I'm going to start the meaning of the term damages and types of damages. Apart from that, I'm going to explain you about some practical problems on remedies for breach of contract. First of all, meaning and types of damages. What do you mean by damage? Damages are the monetary compensation. Damages are monetary compensation allowed to the injured party by the court for the loss or injury suffered by him by the breach of contract. So in a contract agreement, one of the party has breached. Due to the breach by one of the party, the other party, that is injured party, that party will suffer some loss. So according to the rule of justice, the aggrieved party should be set off, should be paid, should be compensated. So these damages are nothing but the monetary compensation which is paid to the injured party in a contract. Whenever there is a breach of contract. So that is the meaning of the term damages. So claiming monetary compensation, one more definition I am giving you, claiming monetary compensation for the loss suffered by the aggrieved party on the breach of contract are called damages. So what are the damages? Claiming monetary compensation. Who is claiming monetary compensation? By the aggrieved party or by the injured party, because they have suffered the loss. The aggrieved party has suffered the loss. Why they have suffered the loss? Because there is a breach of contract. So in a breach of contract, one party will suffer the loss. That party is called aggrieved party. Aggrieved party. So that aggrieved party should be compensated monetarily by that party who has breached the contract. That is called damages. Every party who is put to loss on account of breach of contract will have a legal right to claim the damages. So any party, whichever party in a contract is suffering a loss on account of breach of contract must be compensated, must be paid the damages. Now, the purpose of providing damages, why these damages are provided? The purpose of providing damages is to put the injured party in the same position as he or she was before the occurrence of the loss. Before the occurrence of the loss, whatever was the position of that party to payment of damages is for the purpose of bringing the party to the same position as was there before breach of contract. So this is the complete meaning of the term damages. Now what are the different types of damages? So we can classify the damages into 5 categories. The first category, ordinary damage. Ordinary damage. So when a contract has been breached, the injured party can recover from the other party such damages as naturally and directly arose in the usual course of things from the breach. That means normal damages are those natural damages which are occurred to the injured party. Whenever there is a breach of contract, the injured party will occur some natural damages, usual damages in the course of the things. That natural damages are called ordinary damages. Now example, with the help of an example I am explaining you. A contracts to sell and deliver 50 bags of wheat to B. A agrees to supply 50 bags of wheat to B at rupees 475 per bag. Agreement made between A and B. A has agreed to deliver 50 bags to B at the rate of 475 per bag. The price to be paid at the time of delivery. The agreement was over. The settlement was the price will be paid by B to A on delivery of the wheat bags. The price of wheat rises. So during the meantime, the price of wheat rises to 500 per bag. At the time of making the agreement, when A has agreed to deliver the bags to B, the agreement was made at 475 per bag. But during the meantime, before delivery, the price of wheat bags have increased to 500. Now, A refuses to sell the wheat because the market price have increased. Now A says, I will not supply the bags to B. Then B can claim damages. B can claim damages from A at the rate of 25 rupees per bag. 25 rupees per bag. Because what is the current price? 500 rupees. What was the price at which the contract was entered into? 475. So 25, 500 minus 475, 25. 25 per bag into 50. 50 into 25. That will be the amount of damages that can be claimed by B from A, because A has breached the contract. A has not supplied the bags. That's why the damages can be claimed by B from A. These are called normal damages. Now special damages. Second category. These can be claimed only if the special circumstances would result in special loss in case of breach of contract. If special circumstances are there and special extraordinary loss was incurred to the injured party, not ordinary loss, it is extraordinary loss. If it is incurred by the injured party, then special damages will be paid. Now, when the purpose of the contract was already brought into the notice of the party, these special damages will be charged only when the purpose of the contract was already told to the party. Before entering into contract, the party was told why he is entering into contract, what is the purpose of the contract. Then only special damages can be claimed. But the party fails to serve the purpose. Even after knowing the purpose, the party fails to complete the obligation. Then according to contract, then the injured party is eligible to claim special damages. So if the circumstances are special circumstances, extraordinary circumstances, and the loss incurred was special loss, extraordinary loss, and when contract was made, one party has disclosed to the other party the purpose of the contract. Even after knowing the purpose of the contract, one other party has failed to comply the obligation, then definitely special damages he has to pay. Example. To make this point clear, I have taken one example. B, a trader. B is a businessman. A trader deliver some goods to railway company and ask them to deliver at a place where the festival was held. So B is a businessman, trader. He delivers some goods to railway company and ask them to transport these goods to a particular place where a festival was held. And on the consignment note, it was clearly written that it should be delivered before Saturday. So while delivering the goods to the railway company, B has told to the railway company that these goods must be reached by Saturday only, because the festival is going on there. So before the conclusion of the festival, the goods should be at the festival's venue. But railway authorities failed to deliver before specified day. Already B told the railway authorities that the goods should reach by Saturday, but due to the failure of the railway authorities, the goods cannot be able to be dispatched on Saturday. Then B is eligible to recover special damages for loss of profit from railway. So B is eligible to claim special damages from the railway authorities because on account of delay in transportation, B has lost the profit from the business. Profit from the business. So the court has allowed B to charge special damages from railway authorities. So this is the case on special damages. Now vindictive or exemplary damages. This is the third type of damages. What is this vindictive and exemplary damages? When the reputation or goodwill of a person or family or business is damaged due to breach of contract, damages can be claimed. When a person's goodwill, reputation, good name of himself or family or the business is damaged due to the breach of contract, then in that case vindictive or exemplary damages can be claimed, because on account of this breach of contract, the goodwill of the person or the goodwill of the business was damaged. Now this may happen in case of promise to marry. Normally when this vindictive or exemplary damage will arise in case of marriage contracts, in case of marriage, and this will in case promise to marry or dishonor of a check by a banker wrongly when he possesses sufficient funds to his credit, the court may award exemplary damages. So two normal cases are there where vindictive or exemplary damages are allowed. First case, promise to marry. Suppose if there is a proposal, if there is an agreement for marriage, and in that case there is a breach of contract in marriage agreement, then vindictive or exemplary damages will be claimed because it affects the damage of the goodwill, reputation, name, good name will be affected. Similarly, when the banker has dishonored a check wrongfully, a person is having sufficient funds to the credit in his bank account. In his bank account, sufficient funds are there, but by mistake, wrongfully, the banker has dishonored the check. In that case, the reputation of the business will get affected. Reputation of the business will get affected because wrongly dishonored by the banker. So banker has to pay vindictive or exemplary damages. So next one is nominal damages. So where the injured party has not in fact suffered any loss by reason of breach of contract, the damages recoverable are normal and very small. If there is not much loss incurred by the injured party, if the quantum of loss is very small loss is incurred by the injured, then nominal damages will be allowed. Then why for small damage, why the party is suing the other party? In order, these damages merely acknowledge that the plaintiff has proved his case and won. Only to prove that I am right, that my case is right, I am justified, to prove that I have sued the party for breach of contract, not for getting the monetary gain. We are not putting the damage case in order to get monetary benefit. Simply we want to prove that we are right, we won the case. So only nominal damages can be claimed, very small damages can be claimed. Last one, damages for inconvenience. Sometimes, very rarely this may happen. Sometimes the injured party was put to inconvenience, discomfort. The injured party was put to inconvenience or discomfort, damages will be claimed. This will be proved from the given example. Damages are claimed for physical inconvenience and discomfort suffered by the injured party. Example, A person with his wife and children has took bus tickets for a particular place, but bus has dropped them 5 kilometers before destination. Mr. A, wife and family, they have booked a bus ticket to a particular place. They are going to the particular place, but the bus has stopped 5 kilometers before destination and left them. Then The Mr. A could not be able to find any other facility of transport because it was a midnight. So Mr. A and the family members, wife and children, they have to go by walk to the destination. So a lot of discomfort, inconvenience occurred to Mr. A and family. So they can claim damages. These damages are called damages for inconvenience. So here A and his family were unable to other transportation facility, so they have to walk, reach the destination and suffered physical inconvenience. So A is liable to recover damages from the bus company. These are called damages for inconvenience or discomfort. So I have completed the complete part of the topic breach of contract, meaning then remedies available and what are damages and what are the different types of damages. Now lastly, I will explain you about the case laws problems on remedies for breach of contract. So before starting the problem, I expect my viewers to have a printout of the problems which I have given in the link under my description. So go to the description, last line you will find the link there, take a printout and keep it ready before watching this video. Now first problem. Alisha, a singer, enters into a contract with Chopra. Alisha is a singer and she entered into a contract with Chopra, the manager of a theatre. So Chopra is the manager of a theatre, and to sing at his theatre for 2 nights in every week for the next 2 months. The agreement made between Alisha and Chopra is Alisha will sing in the theatre of Chopra for 2 months duration. Weekly 2 nights she has to come and sing in the theatre. Every week 2 times. For how many months? 2 months contract was made between Alisha and Chopra. Chopra agrees to pay 600 rupees for singing day. So whenever Alisha comes and sing, 600 rupees will be paid by Chopra to Alisha. On the 6th day, Alisha willfully absent herself from the theatre, advised Chopra. Willfully, without any valid reason, Alisha has not performed after the 6th day. Now what remedy Chopra can take? 2 remedies are there. First of all, Chopra can rescind the contract. Rescission of the contract. That means now there is no need to pay Chopra any more amount to Alisha. Contract is rescinded. That means one of the party has breached the contract. Alisha has breached the contract. So Chopra need not perform his obligation of making the payment. Rescind the contract. Secondly, Chopra can put a sue Alisha in a court of law regarding the damages he has suffered. The damages he has suffered because Alisha has breached the contract, she has broken the contract and he is incurring the loss. So Chopra has to prove in the court of law how much loss he has incurred because of breach of contract made by Alisha. So 2 remedies are available in the hands of Chopra. He can rescind the contract and also he can sue Alisha for damages. Next, second problem. Sadat contracts to pay a sum of money to Akhil on a specified day. Sadat contracts to pay a sum of money to Akhil on a specified day. Sadat does not pay the amount on that day. Akhil, in consequence of not receiving the money on that day, is unable to pay his debts and is totally ruined. Akhil claims heavy damages. Advise Sadat. Now see here, Sadat has to pay a sum of money to Akhil. And on the date of payment, Sadat failed to pay the amount to Akhil. And it is given that Akhil was put to heavy losses because after receiving the money from Sadat, he has to pay his debts. When Sadat made a default, breach of contract, then Akhil cannot be able to pay the amount of their debts. He was completely ruined. So he wants to claim heavy damages from Sadat. So what is the conclusion? Advise the Sadat. See here only normal damages can be paid by Sadat. Special damages are not required because when amount is lent to Sadat, he was not told that if you do not pay on time, we will be put to heavy loss. We have to pay to our debtors. So if we cannot be able to pay our parties, there will be a huge loss. This sentence was not given by Akhil to Sadat. In that case, only normal damages will be paid by Sadat to Akhil. And the damages will be at the normal rate of interest from the specified date to the date of payment. The period from the specified date to the date of payment. We calculate the interest charges and normal damages can be paid. Now Akhil is asking for heavy damages. Heavy damages will not be paid to Akhil. Next, third point. Wajid employs Nadeem as manager of his factory. Wajid employs Nadeem as manager of his factory for a term of 3 years at a monthly salary of 15,000. Without any lapse on the part of Nadeem, Wajid dismissed him after 2 years of service. Actually, agreement was made for 3 years. But after 2 years, without any reason, Wajid has dismissed, removed from the employment. So Nadeem, how much Nadeem was getting salary? 15,000 per month. Nadeem could not get any alternate job elsewhere and files a suit for damages for breach of contract against Wajid. Will he succeed? If yes, assess the amount of damages recoverable by him. See, in this case, there is a breach of contract by Wajid. He has removed Nadeem from employment after 2 years. The contract is for 3 years. Now Nadeem is unemployed. He cannot be able to find any other job elsewhere. So he is losing. The normal damages will be paid. The normal damages are the monthly salary for 1 year. The monthly salary is 15,000 per month. So 15,000 per month into 12. It is 1,80,000. So 1,80,000 are the normal damages that can be claimed by Nadeem from Wajid. Next, fourth problem. Sanjeev agreed to act as sales manager for a company. Sanjeev agreed to act as a sales manager of a company XYZ for a period of 3 years at a monthly salary of 10,000. Sanjeev worked for 6 months and then left and joined another company at a higher salary. What are the rights of company XYZ? So XYZ has to prove in a court of law how much loss the company is incurring when the salesman, when Sanjeev was left the company. Sanjeev agreed to act as sales manager. Later he has left the company. So how much XYZ company has lost because Sanjeev have left the company? That the company has to prove in the court of law. Then special damages can be allowed to the company. That means the company can charge special damages from Sanjeev because Sanjeev has left the job within 6 months. The agreement was made for 3 years. So special damages can be claimed by the company from Sanjeev. Next, fifth one. Watson agreed to sell his ship to James. Watson agreed to sell his ship to James for rupees 1,60,000. But James breached the same by not paying the ship. Watson, in want of money, forced to sell the ship for rupees 1,50,000 to others. Explain the justice available to Watson. Actually, Watson agreed. Agreement is between Watson and James. James has breached the contract. He already entered into the contract to purchase the ship for 1,60,000. Later on, James refused to purchase the ship. Ultimately, Watson has sold the ship to another customer for 1,50,000. That means 10,000 rupees loss incurred by Watson. So what are the remedies available to Watson? Explain the justice available to Watson. So two things are there. Watson, first of all, has to resign the contract. He will resign the contract. Second, he can claim normal damages. The normal damages are 10,000 rupees. So actually, the agreement was for 1,60,000, but he was forced to sell the ship at 1,50,000. So 10,000 rupees normal damages can be claimed by Watson from James. Next, last and final problem. A contracts to repair B's house and receives payment in advance. A contracts to repair B's house and receives advance payment. A repairs, but not according to the contract. according to the terms of the contract, the terms they have not followed. So A had repaired, but not according to the terms and conditions of the contract. Is B entitled to recover from A the additional cost of making the repairs as per contract? Yes, according to the law of justice, B can recover the amount from A because A's negligence. A has not followed the terms and conditions of the contract. That's why B has to get it done by others by incurring additional cost. So this additional cost incurred by A can be recovered from A. The additional cost incurred by B can be recovered from A because A has breached the contract. A has not followed the terms and conditions. That's all. So these are the 6 problems on remedies for breach of contract. So these 2 videos have explained you the meaning of the term breach of contract, the types of breach of contract, then what are the remedies available for breach of contract, what are damages and what are the different types of damages, and lastly I have completed the practical problems on remedies of breach of contract. So this is the end of the topic Indian Contract Act 1872. All the topics I have covered. All the best for your preparations. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments on these videos. And lastly, don't forget to subscribe my channel if you have not yet subscribed. Inshallah, in the next video, I'll start up the next topic, that is Sale of Goods Act.